This is video 2, weeks 3 to 4, contracts course, day and night sections. This will be the first video screenshot for the topic set forth in Chapter 3, consideration. We will have a second set of notes for the last part of Chapter 3 and a video screenshot to go with that. My sense is that this will be a shorter video in terms of what I want to cover with it. And at the opening paragraph, and I should have caught this when I posted, but I didn't. The last sentence, the exam that will be posted by October 2, obviously that doesn't apply to this course. We will be having an exam, and I will be giving you ample notice. So in the introductory material, when I identified the 4 elements of a valid contract, I noted, as your authors do, that one of the valid elements is consideration, and we can think of that as a bargain for exchange of legal value. What I want to do here, however, is provide a working definition that's more involved, but will always give us the right answer if we follow it. And this is a definition that's a traditional one, though I don't think it's set forth quite like this in Chapter 3. When we ask the question of whether there's consideration, we really should be thinking in terms of a more specific question, and that is, we're looking at an agreement and we're seeing that someone has made a promise, and we're asking this question: is there legally sufficient consideration to support the promise? Once again, is there legally sufficient consideration to support the promise? So this is our setup, and how we answer that question is yes, there is, if in exchange for the promise, and more of that in the next posting and screenshot video. But in exchange for the promise, the party who receives the promise agrees to perform an act, and if it's a unilateral contract, which is calling for the performance of an act, performs an act that the party is otherwise under no legal duty to perform, or the party receiving the promise agrees in exchange for the promise to refrain from performing an act the party otherwise has a legal duty to perform, or if it's a unilateral contract, in fact refrains from performing an act the party otherwise has a legal right to perform. And in the next couple of paragraphs, I give you examples of both parts of the definition of legally sufficient consideration. So the first one is, in exchange for a promise, the other party promises to perform an act they otherwise had no legal duty to perform. And in the second one, in exchange for a promise, the party refrains from performing an act that the party otherwise had a legal right to perform. Let's talk about the second one a little bit. It's in the book. It's a classic contracts case. It's from the late 19th century, decided, I believe, by the New York Court of Appeals, the highest court in New York. And I don't think there's a student of the law who hasn't been required to read this case or an excerpt from this case. So there was a point in time many decades ago where I read this case as a first-year law student in my contracts course. So it's Hammer versus Sidway. And what you have is an uncle, there's a family gathering. By the way, this case arose in the area around Buffalo now known as Elma. And I think the family had a little bit of money, but it's kind of cool because to me it's like this sort of old-fashioned thing. So the families gathered around. It's some kind of a, I don't know, maybe it's Thanksgiving, but the uncle promises to pay his nephew a certain sum of money, and it was identified. I just forgot what it was. You can check it out in the book. If the nephew did not smoke, drink, or gamble until he reached a certain age. And the nephew, when the uncle made the promise, had the right, legal right, we had sort of different rules then, had the legal right, if he wanted to smoke, drink, or gamble. You know, those were the days. I might add, when I was a teenager, the drinking age in New York was 18. And I don't think that there was a rule about when you could buy cigarettes. And, you know, you could gamble. In any event, it's important to note that when the uncle makes the promise, the nephew had the right to smoke, he had the right to drink, and he had the right to gamble. And the uncle says, well, if you don't do these things, I believe it's until the age of 21. If you don't do these things until the age of 21, smoke, drink, or gamble, I'm going to pay you X amount of dollars. And so the kid reaches the age of 21. He tells his uncle, you know, I haven't smoked, I haven't been drinking, and I haven't gambled. And the uncle said, I know. So there was no question of fact that was ever raised. And the uncle said, I owe you the money. I'm going to put it in the bank. It'll gather interest. Whenever you want the money, let me know. So now the uncle puts the money in the bank for the kid. It's gathering interest, and the uncle dies. Now there's an estate, and there's an executor of the estate, the person who was appointed in the will to run the estate. One of the jobs of the executor is determining whether legal demands made of the estate are actually enforceable. The executor took the position that the uncle's promise to the nephew was not enforceable because the uncle received nothing of value in return for the nephew not smoking, not drinking, and not gambling. And the significance of the case is the court said the uncle didn't have to receive anything of value. Once again, the uncle didn't have to receive anything of value. It was enough, or if you will, there was legally sufficient consideration because in exchange for the promise, the nephew, and I'm going to go back up, refrained from performing an act he otherwise had a legal right to perform. Because he gave up smoking, which he had a legal right to do, drinking, which he had a legal right to do, and gambling, which he had a legal right to do in those days, then the fact that he refrained from exercising those legal rights constituted legally sufficient consideration. I also make the point that in exchange for the promises required, and we'll talk about that more in the next posting. And then the last aspect or part of this posting is the distinction between legally sufficient and adequate. And when we look at consideration, typically courts do not address the question of whether the consideration was adequate, meaning that there was enough money given or there was enough goods exchanged, etc. And when I learned this stuff, the old-fashioned term was the peppercorn theory of consideration. Adequacy is not an issue. What's at issue is, and that's our definition, is there legally sufficient consideration? Now, sometimes, and I point this out, the consideration may seem disproportionate. And we have some legislation that governs or regulates the area of consideration. The law of usury is one. In other words, it puts a limit on how much interest can be charged. Also, if somebody's up to no good by practicing fraud, duress, or coercion, that might be a reason to upset a contract. But if we're purely looking at consideration, or only looking at consideration, and we're not dealing with any kind of a regulation, then so long as we meet the requirements of that definition, then we have legally sufficient consideration, and the question of adequacy simply is not relevant. So that's going to end this posting.